Okay, this is me telling you I told you so. Ladies and gentlemen, ladies and gents, gotta get that introduction out of the way. This is me telling you I told you so, I told you so, I told you so. I told everybody that the courts changed their name. I was just wrong about the date. It was not 1928 or 29, it was 1948. Pay attention, the 12th United States Court of Appeals, now watch this, it was not the United States Court of Appeals, it was the Circuit Court of Appeals for the United States. Okay, are traditionally known as circuit courts. After the Supreme Court was formed, it was expected that the Supreme Court justices would travel around the country twice a year visiting the circuit courts in different states. Unfortunately, travel was a slow and difficult process in the late 18th century. Look, that wasn't the reason. That's the reason today that we will say that was the reason, but that wasn't the reason. But anyway, let's continue. And the justices found it difficult to leave Washington on a regular basis. Although Congress passed several laws, they had steam engine trains back then. Several laws creating new courts, the Supreme Court justices continued to ride the circuit until 1891, when Congress created the Circuit Court of Appeals. Not the United States Circuit Court of Appeals. They were called the Circuit Court of Appeals. Okay, pay attention. In 1948, the official name was changed to the United States Court of Appeals. Now, the official name was changed. No, what they did is they took the United States and put it in front of the name. Okay, this is the administrative court. This is when they went completely administrative. The name change was evidence of that. It went from the Circuit Court of Appeals, pay attention, talking about name change. They're still called the Ninth Circuit Court of Appeals, is it not? The United States Ninth Circuit Court of Appeals. The United States Eighth Circuit Court of Appeals. They're all still referred to as Circuit Court of Appeals. It's just before the United States came after the title. So when it said the 12th United States Court of Appeals, they're doing that on purpose. That's intentional. When you look at the act, matter of fact, where is that stupid act? It's the Judiciary Act of 1787,549 billion. No, the Judiciary Act of 1948. The Administrative Judiciary Act. Okay? That's what you need to know. That's what you should know. That's what you got to know. So we're going to find that act and we're going to be right back. Told you we were going to find it, y'all. Now look, 28 USC. Chapter, United States Code, Chapter 3, which is from Title 28, Judiciary, Judicial Procedures, Organization of the Court, Administrative. Remember, this is 2 years or less than 2 years after the Administrative Procedures Act was enacted. Okay? So, we're going to do the Be It Known. Now, there are 13 circuits that many of you do not know what the 13th Circuit is. The 13th Circuit is interesting. So when you get a chance, look up that 13th Circuit Court of Appeals. Okay? You're going to see, there it is right there. Federal. Federal. It handles all federal district courts. There's a reason for that. Just go ahead, take a look at it, understand it. I gotta search for that particular phrase because it's in this section right here. It's in here somewhere. Let's see. For determination of the United States District Court for the District Canal. Nope, not that one. It's one of these. Let's see. Nope, I gotta put y'all on pause again so I can find it. Ladies and gentlemen, throughout my life, people have accused me of being a know-it-all. And they just hate me because I act like I know it all. It is not that I act like I know it all or that I know it all. I only know everything. But that's all that I know. I promise you I don't know anything else other than everything. Alright? I done told all of y'all. The Act of February 9th, 1893 established a Court of Appeals for the District of Columbia to consist of one Chief Judge, 2 Associate Justices, whose jurisdiction was almost entirely to review the judgments of the Supreme Court of the District of Columbia. The name was changed in 1936 to the District Court of the United States for the District Court of Columbia. Pay attention. District Court of the United States for the District of Columbia, not the United States District Court for the District of Columbia. Circuit courts were established by the First Judiciary Act of September 24th, 1789. Okay? But it was in 1948 that the name United States appears after, pay attention, the Judiciary Appropriations Act. It was 1945, June 26. It was the June 26 Act. That was the act. Okay? They say 1944, but June 26, 1945 was when I was told it was enacted on all the other documents, but this says 1944. Provides that as used in this act, the term Circuit Court of Appeals includes the United States Court of Appeals for the District of Columbia. The term senior judge, blah, 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 for the circuit for the District of Columbia. Okay? And its associated justices of the United States Court of Appeals for the District of Columbia. Remember, it wasn't the United States Court of Appeals. It was the District Court of the United States for the District of Columbia. All of the courts had United States after. Just like you have the United States Supreme Court or, what is it? U.S. Supra. United States Supreme Court of America. Anyway, it was originally known as the Supreme Court of the United States. So if you look at some of their cases, sometimes they sit as the Supreme Court of the United States of America, and other times they sit as the United States Supreme Court. One is a legislative body, administrative, hold on, so y'all can see it. One is an administrative, legislative body. They just perform administrative functions. That's all the Supreme Court does when it's the Supreme Court of the United States. It was the Act of 1925 that made that the case. Okay? Just look at the Act of 1925 that made it to where when they made a ruling, they said as a reviewing body only. When the court sits as a reviewing body, it sits as a ministerial clerk. Okay? We've already gone over that case law. That's why I keep bringing this to you guys' attention. All right? So this is to let you know that this was the act that changed it from the United States to the United States Court of such and such. So instead of the courts being of the United States, it is now the blah blah United States blah 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 court for blah blah blah. Okay? Oh, they amended it. See? That's what happened June 25th, 1948. They amended it. Because they felt like it. So now that you know, now that you got it, you always heard there are two separate governments, two different courts. You can't go into court saying this because many of you have not studied it. You don't know it to go into court saying it. As I was just talking to somebody today, ladies and gentlemen, you have to ask questions that just sound and seem benign, so that when they respond, they can sit up there and all day long try to figure out where you're going, and they have no clue because they don't know. Again, I had a police officer announce and mention that he had a W-2 or a W-4. Well, guess what? That lets us know that his W-2 and W-4 is for a corporation. Well, W-2s and W-4s are only required for corporations. Government agencies are not required to have their employees fill out a W-2, W-4. Why? Because it's a government agency. But that's the employees. You're absolutely right. I am so glad you just said that's the employee. So now, employee W-2, W-4. Now we get to go after the employer. Because if he's an employee, we get to find out whether or not his employer is actually government. Why? Because he just mentioned that he receives a W-2, W-9. Well, W-2, W-9s are only issued to corporations. Corporations are only identified by their employer identification number. We know the United States has an employer identification number. The courts have an employer identification number. The police departments have an employer identification number. And guess what? When you pull up their records, their charters, it shows they're privately owned and who the owners are. Again, you have to set them up by asking some very simple questions to which they think, and they're going to watch my videos because, hey, ladies and gentlemen, if you haven't figured it out yet, they have been watching the videos. Okay, but they're not watching them so that they could learn. They're watching them so that they can figure out a way around the things that are being discussed by myself and others. Well, guess what? They don't have too many videos to watch because not too many people are talking on these subjects. So they can spend time listening to mine and picking up on the different little angles and everything. They think that this is going to cause them to outthink me. No, because my questions are plethora. Oh, what is some more? Can you give me some more questions? No, because if I do that, that'll be playing into their hands, and I don't want to play into their hands. I want to put some other stuff in their hands that's left by baboons and dogs and pigs and cows. I want to put that stuff in their hands and tell them to go have a Coke and a smile. But for right now, I just wanted to bring to you all's attention that the court, when you see the name United States in front, because remember, Congress has amended the Judiciary Act, probably about 75 times, at least. Just kidding, I'm exaggerating when I say 75, but it has been quite a number of times. So guess what happens with the amendment of the Judiciary Act? See, this is the creation and composition of the courts. This is the thing where it was, pay attention, there shall be in each circuit a court of appeals. There was already a court of appeals, which shall be a court of record, known as the United States Court of Appeals for that circuit. Before, it was the Circuit Court of Appeals for the United States. Okay, and then its number. But this was now changing it to the United States Court of Appeals. Each Court of Appeals will consist of, none of that has anything to do with anything other than the fact that now the name was changed from the Circuit Court of Appeals to, as they said, each had a circuit, in each circuit a Court of Appeals. There shall be. And it was known as, we learned before, the Circuit Court of Appeals for the United States. Now it's known as the United States Court of Appeals. Okay, there's still circuit courts, but now the United States precedes the name. That was the change. Now, of course, they're not going to announce that. Of course not. Why would they do that? So let's go back here to change. Changes. Love. That's what love puts us through. Changes. Oh, I'm sorry. Love can make you also fine inside. That is me letting you all know that I'm actually doing pretty good right now, so that you all get it. Because, oh, let's put the D there, because we got to go to the right one. Again, originally the Court of Appeals for the District of Columbia. Again, now don't focus on District of Columbia. Focus on the fact that they were called Court of Appeals for blah, blah, blah. But after this, the name was changed to the United States. The United States, sorry, I gotta correct that. The United States came second here. But now it is the United States Court of Appeals for the District of Columbia. So before, the United States came after the name of the court, the District Court of the United States. Okay, but notice it's now the United States Federal District Court. Okay, or the United States Court of Appeals for the District of Columbia. Now the term United States comes first. Now we say term, why? Because United States, means a federal corporation. And they are a federal corporation. They are created a municipal corporation for municipal purposes. The United States has created a corporation for municipal purposes. Go ahead, DC code 1-102, 1-101. It's all right there. That's what they were doing here. Okay, you notice this right here? DC code? Oh, well, you know what? I apologize, because I keep telling y'all if I mention something, I'm going to take y'all there. I'll take you there. Oh, mercy. So, ladies and gentlemen, let's go there. And we're only going to spend a minute or two on this so that we can go on. So, let's get rid of the stuff we don't need, because we don't need that. And let's go Okay. Now, don't care. Nobody asked about no telephone number. Do y'all see that right there? Telephone number. Nobody said no area code. We said DC code, so it don't want me to do it this way, y'all. And so what I have to do is this way, so that y'all can see what it really is. And see, it's still pulling up area code. And specifically, I'm saying DC code. Alright, got one more thing I need to do. And this is what Google does intentionally, ladies and gentlemen. This is the algorithm. The algorithm, it was specifically and purposely designed to do this to people, to have you looking up stuff. You see, DC code. I don't want that DC code. Oh, that's what it is. That's what it is. It's the 2. It ain't supposed to be a 2. DC code 1-102. I guess I pushed the 2 by mistake. DC code. District is created a body corporate. Okay? The district is created a body corporate for municipal purpose. I done told y'all, I don't speak on stuff if I don't know what I'm talking about, because it makes no sense to speak on it. So now that you know that the district has created a corporation, the corporation is the United States, not the United States of America. Go back and look. The United States of America was not created a corporation. The district was created a corporation, and the permanent seat of government for the United States is the district. Let's pull it up. Let's get ready to rumble. The district has created a government by the name, the District of Columbia, by which name it is constituted a body corporate for municipal purposes, and may contract and be contracted with, sue and be sued, plead and be interpled, have a seal, exercise all the powers of a municipal corporation not consistent with the Constitution, not inconsistent with the Constitution and the laws of the United States and the provision of this code. Ladies and gentlemen, this corporation, known as the District of Columbia, is not sovereign. Why? Because it is a corporation, and anytime the government engages in, pay attention, municipal purposes, commercial activities, it abandons its sovereign capacity and is to be treated as any other corporation. Pay attention, as long as they have an EIN number, they are a corporation. And as a corporation in the United States, they must agree to contract and be contracted with, to sue and be sued, to plead and interplead into cases. That's why this is important. That's why you have the right to contract. That's why the contract works. Ladies and gentlemen, there is some information. We just received some information regarding the gentleman, Mr. Bradley Christopher Stark. And I cannot tell that to you because they've been listening to the videos regarding his situation, me speaking on that. And they've been giving responses in line with that. So I cannot talk about his situation, but guess what I can do? I can let you know that we just got some pretty good news, and on 2 different fronts. So I am a happy camper. Okay? And all of it is due to the fact that we are not... I didn't ask you for municipal purposes. Okay, municipal corporate purpose law and legal definition. Municipal corporate purpose are divided into 2 classes, those which are direct and those which are indirect. A direct corporate purpose is one in which it is direct and immediate consequences operating in the interest of the corporation. Okay? Now, this is Louisiana. Every state has their state government, their county set up as municipal corporations. Let's get ready to rumble! The governing authority of any municipal corporation, including any city, town, village, after making provisions for the payment of all statutory and ordinary charges, may fund into bonds of the municipal corporation the avails and residue a general alimony tax for the purpose of paying and improving and maintaining. Ladies and gentlemen, I want you to pay attention. All government is a corporation, but Louisiana lets you know in their code that they engage in commercial business activity. Anytime government in any form engage in corporate commercial activities, they abandon any claim to sovereignty. Any claim to sovereignty. All government is created for municipal purposes. You'll see that your state government is created for municipal purposes. All you got to do is pull that law and have the, I'll say it, the Clairfield Doctrine, but it's not the Clairfield Doctrine as we've shown you. It is the Planters Bank versus the Bank of Georgia. Okay? So hold on. Let's do that so we can show it to y'all. I don't know what this is. What is this? Out of the box painting design. Nobody asked for nobody, out of nobody's box. But hey, I'm actually glad that it did this. Bank of the West. Get out of here. I don't know who them people is. Bank of the West. I think it's recording my voice. My voice recognition is off. But you notice I just said bank and you saw it pulled up all those things talking about bank. I guess it's Google. Bank of Georgia. And we got Planters, Planters, V. You know what? It's not Planters Bank. It is U.S. Bank versus, yes, Bank of the U.S. versus Planter Bank of Georgia. Okay, that's your original case. That's 1824. That's where you will see that anytime government engages in commercial business activities, even if it's a subdivision, they do not represent the sovereign. So you got a municipal case where somebody's bringing a case against you. Here's how you hammer them in the head. Watch this. We're going to do COMMERCIALBUSINESS. Commercial business. Uh-oh, it doesn't have my commercial business. Okay, well, let's just get rid of the business. Come on now. Oh, it don't want to even give me commercial. I know that commercial is in here. Oh, wait, I apologize. Let's get rid of something. See, this thing talks about this official Supreme Court junk. And that's why I can't find it. Okay, that's what I'm looking for. Whew. All right. Now, let's see if we can find it now. And let's see. Uh-oh, I did the wrong one. F. Come on now. Nope, I can't pull it. It won't let me do it. Disclaimer. It won't let me do it. It won't let me search. Justia, what's wrong with you? So give me a second. I'll find it and I'll be right back. I'm sorry. The reason why I couldn't find it because I was in the syllabus and not in the case actual findings. That is not, we think, a case in which the character of the defendant, someone claiming to be government, gives jurisdiction to the court of the Supreme Court's original jurisdiction to hear matters that involve the United States and another party. Because the Bank of the U.S. and the Bank of Georgia were both claiming to be sovereign, both claiming to represent the sovereign, which would make them automatically jurisdiction in the Supreme Court. Supreme Court is saying, don't think so. If it did, the suit could be instituted only in the Supreme Court. This suit is not to be sustained because the Planters Bank of Georgia is suitable in the federal courts, but because the plaintiffs have a right to sue any defendant in that court who is not withdrawn from its jurisdiction by the Constitution or by law. What are they talking about? Well, this is what they're talking about. Once those corporations incorporated themselves, they allowed themselves to sue or be sued. Okay? That's what they're talking about. Let's go ahead and show you The district has created a government by the name of the District of Columbia, by which name, not the government, but by the name, it is constituted a body corporate for municipal purposes. Because this is a phrase, ladies and gentlemen, is a legal term. It is a legal name. That's why you can't use it, because they've copywritten it. And it may, this body corporate, contract and be contracted with, sue and be sued. Okay, this is what the Supreme Court in Planters is talking about. It says, who is not withdrawn from his jurisdiction by constitution or by law. Because they are a corporation, the law says that they must amend themselves to being sued. Why? Because if they are not capable of being sued, then your corporation is not capable of being sued. Then your person is not capable of being sued. Which means that everybody's immune from lawsuits. They can't do that. The suit is against a corporation. Uh-oh, did you see that? The Bank of the United States and the Bank of Georgia are both corporations. And the judgment is to be satisfied by the property of the corporation and not by the individual corporators. The state does not, by becoming a corporator, a partner to that corporation, identify itself with the corporation. Just because it's set up under the state doesn't mean the corporation is the state, is what they're saying. Pay attention. The Planters Bank of Georgia is not the state of Georgia. They're just a corporation carrying the name Georgia, even though the Georgia statutes may have created the corporation. Although the state holds an interest in it. Again, even though the state by statute may have created the corporation, they are not the state. Let's continue. Let's get ready to... It is, we think, a sound principle that when a government becomes a partner in a trading company, commercial business, it divests itself, so far as concerns the transactions of that company, of its sovereign character. In other words, it abandons its sovereign capacity and takes on the role of a private citizen. Instead of communicating to this company its privileges and prerogatives, it descends to the level of those with whom it associates itself and takes on the character which belongs to its associates and to the business which is to be transacted. Pay attention, ladies and gentlemen. This is a commercial transaction, so it's commercial business. That's what they're saying. Pay attention. I want you to understand how they think of what they think of a private citizen. Now, remember, a private citizen is supposed to have a lot of rights. Whew. Because guess what? The corporation descends to the level of a private citizen. Oops. Thought you knew what you were doing out there, huh? Going out there talking about how you got rights and all that. No, you don't. Okay. Thus, many states of this union who have an interest in a corporation are not suable even in their own courts if this was not to be true. Yet, they never exempt the corporation from being sued. See, if they exempted their corporations from being sued, they would have to exempt under equal protection of law and due process your corporation from being sued. The state of Georgia, by giving the bank the capacity to sue and be sued, when did they give that? When they set up their corporation law. They allow all corporations must agree to sue and be sued. Go ahead and look at your articles of incorporation and your paperwork with the state. Notice how you've agreed to sue and be sued. Well, all of the corporations of the federal government, even though they claim immunity, that's a lie. You need to understand that. All you got to do is say as long as they're engaged in commercial activities, then they are amendable to suit. And everything they did was under, you got to bring up the fact that it was a commercial transaction or a business transaction, that you had a business relationship with them. As long as that's the case, they are not government. And that includes the state government when they want to bring a charge against you by actors who operate from private corporations. Okay, just got to put together the argument, people. Let me finish. Thank you. Voluntarily strips itself of its sovereign character so far as respects the transactions of the bank and waives all the privileges of that character. waives all the privileges of that character. As a member of a corporation, the government never exercises its sovereignty, ever. It acts merely as a corporator and exercises no other power in the management of the affairs of the corporation other than that are expressly given it by the Incorporating Act. You know, I had a judge tell me in a different case, he said that I was not recognized by the court to speak on behalf of nobodies because I did not have a license to practice law. Ladies and gentlemen, now that he's made that comment on the record, since he has stated with his ignorance that one did not have a license to practice law, I just need to find out where does one get a license to practice law in the United States? And if I don't have a license to practice law, then now I get to demand that all of the attorneys in the case introduce their license to practice law. Okay, and I make sure that the case is postponed until they do so. So, ladies and gentlemen, I'm going to let you all go. And we will have this conversation later so that we can continue to show you guys about government and about these courts in the United States. And let's do that. Give me 1 second. I am writing something down because I got something I want to share with y'all. I'm going to keep this case up because this case is important. This is the syllabus portion of the case because it says the same thing. The circumstances that a state is a member of a private corporation will not give this court, the Supreme Court of the United States, original jurisdiction of suits, where the corporation is a party, and oust the circuit courts of its jurisdiction vested in them by law. Okay, so they're saying they couldn't skip those courts. They had to go to those courts. Now, hold on. Hold on, y'all. We need to check on something because I was going to let y'all go, but then I started talking, and we were talking about these corporations. So hold on 1 second. Gotta show y'all something. It's been saying I has no internet, but I has internet, y'all. I don't know what's going on. Been getting in this. Oh, that's right. They tapping into my system. Uh-oh. Hold on. I didn't have an internet. It went into airplane mode for whatever dumb reason. I have no idea why it would go into airplane mode on its own. So y'all hold on 1 second. I guess that was them letting me know that, you know, I made a comment about them tapping into my system, and they were letting me know that they're tapping into my system. So, lo and behold, Kunta Kente. Okay. Now, let's try it one more again, and I may have to, because I got full connection right now, so I'm going to have to do a refresh, so 1 second. Alright, sorry about that, ladies and gentlemen. What I did was I put in here the Supreme Court of the United States. Now, again, many of you are not often hearing of the Supreme Court of the United States. You're hearing often of SOPRA, the United States Supreme Court. Okay? But the original name was the Supreme Court of the United States, not the United States Supreme Court. When they did the name change, that lets you know that there are two different sides. Okay? There are two different sides to the court. One is administrative, as we will show you in later videos, and the other is judicial. That's why I put in here United States Supreme Court versus Supreme Court of the United States. Now, let's see. U.S. Supreme Court Justice, which is the United States Supreme Court. So you're always hearing of the U.S. Supreme Court. Okay, so when you're hearing that, that's administrative. When you're hearing the Supreme Court of the United States, that is judicial. So let's get rid of the second one, if it'll let me. Yeah, let's just do it that way. Okay, so I put the United States Supreme Court, and you notice how Google gives me the Supreme Court of the United States. Go look at the rulings of the Supreme Court and see if you do not see the United States Supreme Court on their documents. Okay, let's see. Got away from my video. We're going to do a Supreme Court of the United States acronym. The reason why I want to do the acronym so I can show you in the spelling of the acronym that, because you guys have the President of the United States who sees SCOTUS. See, this is the Supreme Court of the United States. That's their acronym. But take a look. The United States Supreme Court. Redirected from the United States Supreme Court. Okay, please understand that there are two different courts. One is SCOTUS. When you hear SCOTUS making a decision, it's usually on a constitutional issue. Okay, but they do hear other cases. But again, you have the Supreme Court of the United States Supreme Court. It even tells you right here, and this is abbreviations.com. The Supreme Court of the United States Supreme Court. There are two different courts, just like you have the District Court of the United States District Court. They kind of get tired of me because whenever I'm writing the court, I always change their title. I let them know exactly the court I'm trying to get into. Now again, you can't have the argument unless you know what you're talking about. So you got to know what you're talking about. Ladies and gentlemen, I'm going to unknow what I talk about because I got to go. Let y'all go. Have a good day. Just wanted to bring this to y'all attention about the difference in the courts and about the commercial business and about how government cannot engage in commercial business. And if they are engaging in commercial business, you can set them up to take care of it, to get things done the proper way. See? USSC, United States Supreme Court. Just got to pay attention because they're telling it to you all day long. Have a good day. Have a good night. Have a good life. Have a good bye, everybody.